This is Bloomberg Law.
Employers frequently exploit the weaknesses in the law.
Courts are going to be asking questions about separation of powers.
One by one, Google settled with all of these other plaintiffs.
Interviews with prominent attorneys and Bloomberg legal experts.
Joining me is immigration law expert Leon Fresco, First Amendment law expert Caroline Malik-Corbin,
And analysis of important legal issues, cases, and headlines.
The trial judge may well want to hold a hearing. They have never said this case should never have been brought in the first place.
Bloomberg Law with June Grasso from Bloomberg Radio.
Welcome to Bloomberg Law. I'm Amy Morris in for June Grasso. June will be back next week. Ahead in this hour, we look at a consolidation effort in the federal government that might leave some disabled contractors at risk. Plus, the trial of Sean Diddy Combs. We'll get into some of the legal twists in the trial of the music mogul. But first, we look at how Supreme Court rulings on Biden administration policy could end up threatening President Trump's sweeping global tariffs. The Supreme Court ruled against a few key climate change and student debt initiatives of then-President Joe Biden using what's called the Major Questions Doctrine. And now that same doctrine could be used to challenge the legal standing of the Trump administration's tariff practices. Joining us now to discuss how this could play out, Bloomberg Supreme Court reporter Greg Stohr. Greg, always a pleasure. Thanks for taking the time with us. First, let's look at the Major Questions Doctrine. What does that say?
Yeah, Amy, the Major Questions Doctrine is something the Supreme Court had never mentioned explicitly until 2022. But in this case involving climate change, the court's conservative majority said, when there is an issue that has major political and economic significance, like climate change, if Congress is going to tell a federal agency you have the power to do something, we expect Congress to be very explicit in doing that. Otherwise, we're going to interpret the law as not giving the agency that authority. And that is something the Supreme Court has used again in restricting what the Biden administration could do.
Okay, so let's break this down. How was this used against some of those Biden administration initiatives? I know it was specifically environmental, like climate change.
Yeah, so I mentioned the 2022 case. It actually stemmed from something Barack Obama had tried to do, his so-called Clean Power Plan, which would have the EPA was going to put limits on greenhouse gas emissions from power plants, trying to basically shift energy production away from coal-fired plants. And the Supreme Court, in a case, the procedure is kind of complicated, but not really important. The essence of it was the Supreme Court said, even though the Clean Power Plan hadn't gone into effect, we're going to evaluate it and determine that the EPA did not have the authority to do this. Congress in the Clean Air Act wasn't specific enough. And that ended up limiting what Joe Biden could try to do going forward on climate change, because as with so many areas in this day and age, climate change is an area where Congress really hasn't said a whole lot, that the agencies had been trying to use really old statutes, decades old statutes like the Clean Air Act to do things. And in that context, the court said, no, you don't have the authority. It meant that Congress would have to do something.
Okay, so this is a matter of authority then. How does this then apply to tariffs? It seems very different from climate change and student debt.
It's very different, but the concept is certainly at least arguably applicable, because Donald Trump's tariffs, of course, are certainly of major economic and political importance. Mm-hmm. And the fight that's been going on in the courts, primarily the Court of International Trade here in Washington and now the Federal Appeals Court, the Federal Circuit, is over whether a statute Congress passed dealing with emergency situations and things the president could do in emergency situations, whether that statute gives him the authority to do what he wants to do. So it's similar to kind of how the Clean Air Act, which was enacted without thinking about climate change at the time, because it wasn't really a thing when Congress passed that. It's the same sort of thing where Congress passed this statute, and nothing in it specifically says the president would have the power to enact worldwide sort of indefinite tariffs totaling billions or trillions of dollars. And so the argument is somewhat similar.
In a situation like this, did the Biden administration, or now the Trump administration, because the Court of International Trade invoked this same doctrine against those tariffs, did either administration have a defense? Is this a case that can continue?
So in both cases, the administration said, hey, if you look at the words of the statute, it's actually enough. That the statute gives us the authority to do what we want to do. And they also, the Biden administration was able to argue at the time, hey, this notion of the major questions doctrine isn't really a thing. Don't superimpose this thing that kind of puts your thumb on the scale against us, puts your thumb on the scale against an agency being able to do something. That ship has sort of sailed. The Supreme Court has said, yeah, we're going to put our thumb on the scale in these circumstances. The other thing that Donald Trump is able to argue in this context is, the Clean Air Act case involved the EPA. It involves a federal agency, and the question was whether Congress had delegated the authority to this agency. Mm-hmm. In this case, the authority that Congress has delegated through the statute known as IEPA was directly to the president, not to an agency. And so they are arguing, among other things, in this context, hey, this major questions doctrine doesn't even apply. In fact, you should be very deferential to the president because we're dealing with an area involving foreign affairs where the president, everybody agrees, plays the leading role under a constitutional structure.
Well, that kind of changes my next question. I wanted to know if the major questions doctrine was sort of a way to rein in the power of the executive branch, but it sounds almost like it's a way to balance the power among the different branches of government.
That is certainly how the court thinks about it. It has had the effect, in Democratic administrations of reining in those agencies. But the way the court has articulated it, and they haven't, said a whole lot, but basically the way the court has looked at it is to say this is something that enforces the constitutional separation of powers, ensures that Congress is able to do what it is trying to do, and that its words are not being taken to give the president, another branch of the government, more power than or an agency at least, more power than Congress intended. So it is, for those proponents of the major questions doctrine, it is something that is designed to make sure everybody stays in their constitutional lanes.
Is the major questions doctrine something that is invoked frequently? Is it an archaic rule that is being trotted out as people feel like they need to rein in other branches of government? How archaic or how new is this?
So the phrase itself is new. The Supreme Court hadn't actually used it in an opinion until 2022, and it's only used it one time since then in the case involving that you alluded to, Joe Biden's effort to slash student debt. Mm-hmm. The concepts have been there, and when the court used the phrase, it said we're just taking the concepts and applying them. So you could look back at a couple other Biden cases involving things like his effort to require workers to either get a COVID vaccine or take weekly tests. The court sort of used that notion that this is such a big thing that we're expecting Congress to have been a little more explicit if it was letting the federal agencies enact such a thing. In terms of going back beyond that, there's a real debate as to whether this is sort of a creation of the court's conservative majority or if it is actually something that is more steeped in decades of Supreme Court tradition.
Could this argument between the Court of International Trade and the Trump administration over tariffs, could that case wind up before the Supreme Court?
I would certainly expect it to in some form. So as you and I talk, we are waiting, and this probably won't happen until next week sometime. We're waiting for this federal appeals court known as the Federal Circuit here in Washington to say whether it's going to let the tariffs stay in effect while the litigation goes forward, potentially for several months. If that court says, no, we're not going to let those tariffs be in effect, then I would expect the administration to very quickly turn to the Supreme Court. Now, this would just be an emergency application, most likely, where they would say, hey, let us put the tariffs in effect while we fight over stuff like the major questions doctrine. But it's certainly possible that it will get escalated quickly, either by the administration or by the court, and sweeping questions about whether these tariffs are legal at all.
All right, we're going to shift gears now, Greg. We're talking with Bloomberg Supreme Court reporter Greg Stohr, and there have been some recent Supreme Court decisions just handed down this past week. Let's get into them, and we'll do this kind of quickly. The gun makers that were shielded from Mexico's lawsuit based on some U.S. laws that shield gun manufacturers, the court ruled in favor of the gun makers. Is this more of a technicality than maybe on the merits? What say you?
It's certainly a case that's very definitive for this Mexico lawsuit. The question about how much impact it's going to have more broadly kind of remains to be seen. The court said that Mexico did not have, they were alleging that the gun industry aided and abetted drug cartel violence in Mexico. And the Supreme Court essentially said this complaint is not nearly specific enough for that sort of allegation to go forward. There's another legal argument that the gun makers were making that would have been even broader, would have thrown out even more lawsuits. So the people on the gun safety side of this argument are breathing a little bit of a sigh of relief that the court's ruling did not go farther than it did.
And the Supreme Court also revived a straight woman's job bias lawsuit, which appears to allow more reverse discrimination cases to be brought.
Yeah, in some parts of the country, some federal appeals courts had said that when a straight person, a white person, a man tries to file a lawsuit saying I was discriminated against in the job, that they had to show a little something more to get their case to the jury. They had to show something called background circumstances to support the suspicion that the defendant is the unusual employer who discriminates against the majority. And the Supreme Court unanimously said no. Every plaintiff, whether they're whatever race, whatever gender, has to prove the same thing. Nobody has a special requirement like that.
Interesting. And we're going to have to leave it there. Greg, thank you so much for taking the time with us. Bloomberg Supreme Court reporter Greg Stohr. Now, coming up, we turn to the Trump administration's dismantling of federal agencies and how those with disabilities might wind up caught in the crossfire. I'm Amy Morris, in for June Grasso, and this is Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
I'm Amy Morris, filling in for June Grasso. The Trump administration is pushing a budget proposal that would put the Equal Employment Opportunity Commission in charge of policing federal contractors for bias against people with disabilities. As of right now, however, the EEOC does not have the authority to audit companies. This is a complicated situation. We welcome Bloomberg's Rebecca Clark to help clear all of this up. Rebecca, thank you so much for taking the time with us.
Yeah, thanks for having me.
Now, first, let's get a little background. We're talking about the EEOC, the Equal Employment Opportunity Commission, and we are talking about the OFCCP, a completely different agency. What does each one do?
Right. So, the EEOC is an agency that's very charge driven. So if you're a worker and you want to file a charge of alleging that your employer discriminated you in some way, you can go to the EEOC or to a state or local agency. And that's really where their power lies. They also have some sort of guidance and policy rulemaking abilities, but they're really charge driven. So it's more of a reactive approach to discrimination. The OFCCP, which is or was a Department of Labor sub-agency, that's the Office of Federal Contract Compliance Programs, they oversaw similar, anti-bias, anti-discrimination work, but for federal contractors. So if you were a company doing business with the government with contracts of certain sizes, you had this extra level of proactive work that you had to do to ensure that you weren't discriminating against your workers. And part of what they were able to do is do these audits of companies. So, there doesn't have to be any sort of evidence of discrimination happening. If you were a company that does business with the government, you'd have these regular audits where you could, they could come in, look at sort of your policies and what's happening there. and then, take action based on that. The Trump administration, through an executive order, sort of sought to eliminate the OFCCP in terms of most of the work that it had been doing on race and sex-based discrimination, because that was all established through an executive order. There were two other statutory obligations that the office sought that they can't undo through an executive order. And one of those is Section 503 of the Rehabilitation Act, which looks at anti-discrimination of disabled workers. And that's through this budget proposal. What they're proposing to have the EEOC enforce now is sort of looking at this anti-bias work against disabled workers at federal contractors. But again, it sort of leaves some of these potential gaps depending on how this goes through, since the EEOC doesn't necessarily have that power already.
All right, let's get into all of that. Now, you mentioned what's left of the OFCCP. That's the federal contractor a group. That they're the ones who watch out, make sure that there's no discrimination among the federal contractors. And on the surface, it looks as though they're kind of similar positions. But you talked with a former director there, Larry Lorber, who says they do not have the same function. What is his take on all this?
Yeah, so, I think, a lot of these former officials, and I think from the outside, it seems like here are these two agencies that are both handling anti-discrimination work. I think the core of the difference is that the work that the OCCP was doing is more proactive approach to limiting discrimination. So they're able to audit these companies without having any sort of evidence of discrimination happening and do more of that investigatory work, versus the EEOC largely doesn't have the power to investigate companies unless they already have evidence, or in most cases have a charge of a worker coming forward saying, I've been discriminated against. And that power really allowed the OCCP to look at large companies that do business with the government and try to find these, spots where there might be discrimination happening, even without a worker coming forward. I know something that I've spoken to about attorneys in this area, as well as former officials, is that it often, found these gaps, especially in terms of hiring or discrimination on that front, where you might, as an applicant, not know that you are being discriminated against. But if they're able to look at all of this data and audit these companies, those were some of the areas where they were able to find discrimination.
As you mentioned, the EEOC doesn't have that authority. Do they intend to get that authority? Is there a way for the administration to grant them that authority to help fill those gaps? Or is this a congressional issue?
Right. So I think, some of these appear to be some open questions where it's a little unclear exactly how this is going to go down. It seems pretty clear from most experts I spoke to that this is something that Congress is going to have to reauthorize in order to give Section 503 enforcement to the EEOC beyond just approving the budget, since statutorily it granted it to the Department of Labor. And since they're moving it to this outside agency, most people think this is going to take an act of Congress to do that. Another aspect of this, though, is that the actual statute itself doesn't necessarily have that auditing power within it. That's something that came from regulations and rulemaking over time. So I think it's, remains to be seen if, in taking over that power, if the EEOC would also intend to use the audits or not. And I think, some of what I was hearing from experts and people who have worked in this field before of OCCP compliance, it seems like either if EEOC does do this, it could be a pretty significant expansion into sort of their power and sort of the scope of their enforcement, or if they choose to leave the auditing to the wayside and not enforce that aspect, then seemingly left in a similar situation where now nobody is auditing for this the way that OFCCP was.
Clarify something for me. You had already mentioned that hundreds of people at the OFCCP have already been laid off, except for those very few who would be helping with these cases under Section 503. And then, of course, they would wind up working for the other agency, the EEOC. Is this already underway? Has this already happened?
So, right, at the same time as we're seeing this happening, what's left of the statutory obligation, so there's Section 503, which is being proposed to go to EEOC, as well as a similar statutory obligation for veterans, for discrimination against veterans, which is proposed to be rehoused somewhere else within the Department of Labor. Those weren't as major of a focus of what the OFCCP was doing based on sex and race discrimination, which has been rescinded through this executive order. So, sort of as part of that, the OFCCP has already put many workers sought to lay off almost the entire workforce. That's been held up, due to a pause on broader federal layoffs. They're keeping only a small portion of staff on now. I think it remains to be seen, if they plan to move people around into these other agencies and how they plan to do that. I think some of that could also be tied up in how these court cases go about the federal worker layoffs. I know that the EEOC did request in its budget a little bit more enforcement, like more money from Congress for, enforcing Section 503 and sort of expanding that. So I think some of this will come down to what budget's approved and how the EEOC goes about this, as well as still some of those open questions on how these proposed layoffs are going to go.
So then what is happening now to those cases that were already pending with the OFCCP?
Right. So that's another thing that I'm, hearing from workers that are there that are, even before the layoffs, there was a memo that went around saying because of the president's executive order, all of this work had been paused. So not just the work on race and sex discrimination that they sort of overturned by rescinding that executive order, but work like the cases under Section 503, as well as those audits, have all been held in abeyance. So, if you're someone who had filed a complaint with the office, you're basically left in this waiting period and in this limbo where you're not exactly sure what's happening with your case. You're not getting updates because, the workers there have been told not to do anything. And now the vast majority of them are also on administrative leave.
So what recourse is there then for those workers impacted and those whose cases are affected? And if you think about it, just from the way you've described it, you have the OFCCP workers. They were laid off. The EEOC workers who now have to take on an entirely new workload with which they are not only not familiar, they'd have to be retrained for, plus those cases that are pending or in limbo for those other workers who are not part of either agency, but they are, using those agencies to help them out in their cases. So is there a way to untangle this? This seems like it affects hundreds of people, if not thousands.
Yeah, I mean, all of these cases are being held up now. I think, for some cases there are, circumstances where things, are considered dual filed between the OFCCP and the EEOC if there's overlap in both of these. But, the EEOC historically has been under-resourced. They, have a higher caseload than I think they're managing. So this would definitely, be adding to that without sort of a clear distinction on if they're going to be getting more resources in order to make up that workload, especially sort of, with this period in time seemingly adding to some of that backlog.
So are we bound to see some of this show up in court cases challenging the president's authority to do this? Or are we more likely to see this show up on Capitol Hill asking Congress for help in the president's authority to do this?
Right. I mean, I think it seems pretty clear from experts I talked to that the aspects that he overturned with the executive order, it was, made through an executive order. So there was the power to undo that. I think, it remains to be seen if potentially a future administration would try to bring that back and if they would do that through, totally restoring the OFCCP or trying to use some other agencies or elsewhere in the Department of Labor to do that. I think, the next steps really are to see what Congress does in terms of if they give this authorization to the EEOC and what power they get with that, as well as sort of through the budget process, what resources they're given for this.
Okay, so at this point, Rebecca, what are you going to be watching for as this progresses?
Yeah, I think a big part on this is sort of looking, trying to hear from people and see what's going on with these cases that we mentioned are sort of paused and trying to understand that impact on this, on, veterans, on disabled workers. I think another aspect to look for will be sort of in this budget process, what resources the agency is given and, if they're able to really take on this workload.
All right, Rebecca Clark with Bloomberg Industry, thank you so much for joining us and for trying to help clear all of this up for us. It does sound like a little bit of an alphabet soup because of all the acronyms, but it is an important issue, and we're going to continue to follow it with you. Thank you, Rebecca, for joining us.
Thank you.
Up next on Bloomberg Law, we're going to turn to the trial of Sean Diddy Combs. We're going to look into some of the testimony that we've already heard and what some of the defense is going to be for the music mogul. I'm Amy Morris, in for June Grasso. This is Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
I'm Amy Morris, in for June Grasso. June will be back next week. And we're watching the explosive trial of entertainment industry mogul Sean Diddy Combs. Several people, including his former girlfriend, singer Cassie Ventura, have testified in this high-profile case with some disturbing testimony. Here to help us break it down is Dave Ehrenberg, managing partner of Dave Ehrenberg Law and former Palm Beach County State Attorney. Dave, it is a pleasure. Thank you for joining us. Sean Combs faces 5 criminal counts, including racketeering, conspiracy, sex trafficking, transportation to engage in prostitution. Some witnesses have testified under oath, but they took the 5th so that they could be granted immunity. Explain how that works. Why are these witnesses looking for immunity in this case?
Good to be with you, Amy. It's because they worry about their own criminal liability, whether it's someone who did drugs, sold drugs, or perhaps was a participant in the schemes themselves. They want to make sure they're not going to step on a landmine, and they all are represented by lawyers themselves, because once the feds start calling you, you call a lawyer, and the lawyer probably told them, don't say a word unless they give you immunity. And the feds are not interested, it seems like, in prosecuting anyone else for these crimes except for Diddy, so they were quick to give everyone immunity.
That's interesting. I wondered, because one of the things he is charged with is racketeering conspiracy. Conspiracy means more than one person. Could Combs also be taking other people down? Are we looking at other possible defendants down the line?
Perhaps, but they would have to be defendants who did not get immunity, because once the feds give you that immunity, then that pretty much is it. I mean, there are opportunities if the feds develop a case independent of the testimony, but it looks like the feds are not interested in others. They want to go to the top of the food chain here. And yes, you're correct in that the racketeering charge does require there to be a criminal enterprise. That means, did Bad Boy Records become his henchmen to commit crimes? So it's not just some legitimate record label, but rather an enterprise to commit crimes to do his bidding. That means there have to be others involved, other employees. That's why you're seeing so many employees called to the stand, because that shows racketeering, and it also shows that a lot of people got immunity for their conduct.
Now, drug use is factoring into some of this testimony. We're hearing about everything from marijuana to cocaine, ecstasy, ketamine, and as you mentioned in your first answer there, a lot of people who might have been involved in that drug use are getting immunity because of that. Could that drug use, though, be a defense for Combs?
Yes, it's being used right now to undermine the credibility of witnesses, saying, you really don't remember this, right? Because you were under the influence of drugs, and you sold drugs, and you were involved with so much drug use. And that tarnishes the witness in front of the jury, because you have jurors who probably are not involved in the world of freak-offs and rampant drug use, who are seeing this outer world that they don't understand, perhaps, and they may just throw up their hands and say, a plague on both your houses. That's a strategy of the defense team.
Is that usually an effective strategy?
Well, it's a strategy because defense lawyers are stuck with the facts that they're given. And here, the facts are pretty damning against Diddy. So they're going to try to muck it up by saying that all these witnesses engaged in drug use, they were all consensual partners in this weird freak-off game, and it's all consensual. So that's the kind of stuff they're saying. Now, you could have a consensual freak off and then the consent gets revoked at some point. For Cassie, at the beginning, did seem like she was interested and a willing participant. And she would say it's because she loved, at least she thought she loved Diddy, and she wanted to please him, and she was scared of him. And at some point, she said that she wanted to stop this. So you can revoke your earlier consent, and then it would be human trafficking, and then it could be racketeering, where there are predicate acts that Diddy allegedly committed, like arson and intimidation of witnesses and extortion and others, human trafficking, that could lead to a guilty verdict here. So, life is complicated. This case is complicated because you have victims who at some point did seem like they were willing to go along, but doesn't mean that that consent lasts forever.
Now, one thing that does keep coming out in testimony is that so many people, mostly women, were victimized but said nothing. Some women even described themselves as being brainwashed. I wonder if the defense could also seize on that and then downplay it, because in some of this cross-examination, clearly they're trying to make the witness less credible, make them look like they're lying or just confused.
Yeah, it's a good point, because the defense is trying to put the witnesses and the victim on trial as well. Now, in a trial, it's only the defendant who's on trial, but the jury will look to see if they like the witnesses, if they believe the witnesses, if they believe the victim. And if they don't believe part of their testimony, they have the right to disregard their entire testimony. And that's what the defense is trying to do. They're trying to poke holes, to say, you don't remember this, you were on drugs there, you were engaged in voluntary prostitution, or you're a sex worker and that's your profession. And then they look at the jury, they say, you see what we're dealing with here? And they're hoping that at least one juror sympathizes with the defense, or at least doesn't like the witnesses or victim. And if that happens, then that's a hung jury. And if everyone has reasonable doubt, or this is not, it would be a reasonable doubt because it's a federal criminal case, then it would be an acquittal.
You've been following this so closely from the very beginning. What is the most damning evidence that the prosecution has against Sean Combs, if it's not just his word against their word?
The most devastating evidence is that video from the Intercontinental Hotel. That video has been shown multiple times at the trial, and that video speaks volumes. It shows Diddy engage in serious violence against Cassie. So when Diddy says that there was no force, fraud, or coercion here, well, what was on that video? What did we just watch? We can see with our own eyes. And essentially Diddy's defense is, who are you going to believe, me or your lying eyes? Well, that video does tell that Diddy engaged in the force or coercion needed to establish human trafficking. And it also can lead to racketeering, in showing that he used force himself to put others under his thumb, to make others comply with his will. And that's why they engage allegedly in arson and witness intimidation and extortion and all these other things like human trafficking. So that video is the most powerful evidence. Now,
is that the summation of the defense strategy that Combs' team has, is that the witnesses may be lying, they're confused, and that technically this really shouldn't be tried in this court for this venue anyway?
Yes, what Diddy is trying to say is that he acted badly there. He was a jealous boyfriend, and perhaps this is a domestic violence case, which is prosecuted in state court, not federal court, and this is not a state court case. And so that's why he's saying that this is not unlike any other basic domestic violence case. It's based on jealousy. In fact, in that video, that infamous video at the Intercontinental Hotel, you see him grabbing for her phone. So he's saying, you see, I was jealous. I want to know what's on her phone. This is a lover's quarrel, and I admit I acted badly, but it's not human trafficking. Human trafficking is commercial sex acts involving force, fraud, or coercion. The sex acts involved here, according to Diddy, were consensual. That fight was separate from the freak-offs. She was consenting to the freak-offs, but when it came to the fight, that was purely domestic violence and should be seen as such. That is a big load for the jury to have to separate the two, to have to say, yeah, you're right, he acted badly here with force and coercion, but it had nothing to do with the underlying freak-offs. I don't buy it. I don't think the jury will buy it either.
There's another witness also who testified that Combs dangled her from a balcony, and it wasn't his girlfriend, it was a friend, and that she was dangled from like the 17th floor balcony. Does that testimony help the prosecution with the weight of the video? I mean, Diddy can make the argument, or his team can make the argument that the video shows a domestic case, but it seems like dangling your aide or your girlfriend's friend from a balcony wouldn't necessarily be a domestic.
Right. I'm sorry to even laugh because you're right. See, this is the mountain of evidence that the prosecution has here. And racketeering was invented to go after the mafia. But it's not just for the mafia anymore. We saw it used in a variety of cases, including one against R. Kelly. So you've got a music mogul who was taken down by racketeering. And if you don't want to be charged like a mobster, then don't dangle someone over a balcony. But that's what he's been alleged here of doing. That's what this witness said that he did to her, and they're desperately trying to poke holes in her story.
Could Combs also face civil action once this criminal trial is over?
Oh, 100%. He's already facing civil action. And when you're a wealthy guy, apparently he's worth $250 million. Yeah, he's going to be tied up in civil lawsuits forever. And the question is whether he'll face them from a prison cell or whether he will be living the high life again. Either way, he's not getting out of this entirely.
And as we've established, you've followed this case from the very beginning. You've been watching the trial. You've been keeping a close eye on all of it. Have you ever seen anything like this?
Well, I don't know. I've never seen anything like this. I mean, the R. Kelly allegations were somewhat similar, but to have arson and a whole team of people around you who were trying to exert force to have you comply with their will, I think the closest thing I've seen is the R. Kelly case, but this takes it to another level. I mean, no matter what happens here, the defendant, Diddy, should be tarred and feathered in the court of public opinion. He has acted so badly that he should not be accepted anymore in polite society where he gets invited to the Met Gala or gets to pretend that he didn't do all these things. I mean, this is absolutely despicable behavior. I mean, the baby oil and the drugs and the steps that were taken to cover everything up and the extortion allegedly and the arson allegedly and putting people over balconies allegedly. And just that videotape alone, the video alone, which we didn't have a video in the R. Kelly case. So the video of Diddy committing terrible violence against Cassie, manhandling her, that alone should just get him canceled. And I'm not one who likes cancel culture, but this is a guy who deserves to be canceled.
And just finally, one big difference between Diddy and R. Kelly is R. Kelly was a music artist, but Diddy was a mogul in music industry, in the food industry, in the fashion industry. And as you mentioned, worth $250 million. And go back 20, 30 years, he helped change how the music industry, the R&B industry operated. And this trial is pretty damning.
It's terrible. In today's society, it seems like everyone can make a comeback and that nothing sticks to people anymore. But, man, this should stick to him. This guy's a bad dude. And I'm hoping that there'll be justice done in this case.
Our thanks to former Palm Beach County State Attorney and Managing Partner at Dave Ehrenberg Law. Dave Ehrenberg, thank you so much for joining us. That does it for this edition of Bloomberg Law. I'm Amy Morris, in for June Grasso. This is Bloomberg. Stay with us. Today's top stories in global business headlines are coming up right now.